All right, welcome back, fellow philosophy enthusiasts. Today we're diving into a concept we all think we get evidence, but, as always, things get a bit more, intricate when we look through a philosophical lens, and especially when we bring in the legal system. So today's deep dive is going to explore how this seemingly simple idea of evidence gets kind of like reshaped and redefined within the legal world.
Yeah, it's a great topic because it forces us to think about how we know things, how we justify beliefs, and ultimately, how we establish truth, all within the very specific and sometimes peculiar framework of the law.
Exactly. And to guide our exploration, we'll be drawing primarily from the Stanford Encyclopedia of Philosophy, specifically the entry on the legal concept of evidence.
Right. And what we're aiming to do is kind of unpack how this idea of evidence, something we use in everyday life, in arguments and science, takes on these unique forms and functions within the legal system.
Yeah, so it's not just about courtroom dramas or, those aha moments with a smoking gun. It's really about understanding how the law attempts to grapple with knowledge, proof, and ultimately the pursuit of justice.
Exactly. And to give you a taste of where we're headed, we'll be looking at a few key areas. First, we'll kind of dissect the fact that evidence isn't this singular monolithic concept in law. It actually has multiple meanings, which can be a bit tricky.
Right. And then we'll explore those essential criteria that something needs to meet even before it's considered, real evidence in court. Things like relevance, materiality, admissibility. These are the gatekeepers, right?
Yeah, absolutely. And after that, we'll get into the thorny issue of how we actually evaluate the strength of evidence. We'll touch on the role of probability, different ways of conceptualizing it, the whole shebang.
Okay, so multiple meanings, criteria for entry, and then assessing strength. What's the final stop on our evidentiary journey?
Well, we'll wrap up by delving into some of the, I think, really fascinating philosophical debates surrounding legal standards of proof, beyond a reasonable doubt, that kind of thing. We'll consider whether mathematical models can truly capture what's going on there.
Ah, yes, the age-old question of whether you can truly quantify something as complex as, legal proof.
Exactly. So, buckle up, philosophy friends. We're about to unpack the legal concept of evidence.
All right, so let's start with that first point, the multiple meanings of evidence in the legal world. It's not as simple as it might seem, right?
No, it's definitely not. It's interesting. The Stanford entry actually points out, going back to a legal scholar named Stephen, who wrote back in 1872, that legal discourse doesn't always use evidence in a really consistent way.
Oh, really? So even back then, there was this ambiguity around the term.
Yeah, it seems so. But let's try to break it down, make some sense of it all. The first meaning, and this is probably the one that, aligns most closely with how we use the term in everyday life, is evidence as, the stuff that's presented in court, the things that are put forward to try to establish facts.
Right. Like the concrete things you bring to court, the raw data, so to speak.
Exactly. And the Stanford entry connects this to the philosophical idea of objects of sensory evidence, which I think is a helpful way to think about it. The things we can perceive, the things we can, directly experience.
Okay, that makes sense. So what kinds of things fall into this category of presented evidence?
Well, typically it comes in three main forms. First, you have oral evidence. That's basically what witnesses say under oath, their testimony. Then there's documentary evidence. This includes all sorts of written materials, things like contracts, emails, letters, you name it. And finally, you have what's called real evidence.
Real evidence. So not fake evidence.
Well, hopefully not. No, real evidence refers to physical objects that are brought into court, things like a weapon, a piece of clothing, a DNA sample, tangible stuff.
Okay, got it. So, to illustrate, imagine a theft case. A witness testifies they saw the accused leaving the scene with the stolen goods. That's oral evidence. A security camera recording shows the same thing. That's documentary evidence. And then the actual stolen item is recovered and presented. That's real evidence.
Perfect example. You've got all three types right there. And notice how each one contributes a different kind of information, a different way of piecing together what happened.
Right. It's like building a puzzle, but with facts instead of, cardboard pieces.
Yeah.
Okay, so that's evidence as the presented information. What's the second meaning of evidence in this legal context?
So the second meaning is a bit more abstract. Here, evidence refers to a factual proposition that's been established through that first type of evidence, the presented stuff. You could call it an evidential fact. It's a fact that's been derived from the evidence.
Okay, I think I'm following. Can you give an example?
Sure. So let's stick with our theft case. A witness testifies they saw the accused at the scene of the crime, let's say a jewelry store, right around the time the theft occurred. Now, the witness's statement itself, that's evidence in the first sense.
Right, it's the presented oral evidence.
Exactly. But if the fact finder, the jury, or judge believes the witness, accepts their testimony as truthful, then the proposition the accused was at the jewelry store at the time of the theft becomes evidence in the second sense.
Okay, I see. So it's like the first type of evidence is the raw material, and the second type is the conclusion you draw from that material, the fact you establish.
Precisely. And of course, the fact finder has to do the work of determining whether they believe the witness, whether they accept that proposition as true. It's not automatically established just because someone says it, right?
Right, that makes sense. And with real evidence, like the stolen necklace in our example, well, the fact finder can just directly observe it. There's not really an inference needed there.
Exactly. But you see how the term evidence is shifting its meaning, depending on whether we're talking about the presented information or the established fact.
Okay, I'm with you so far. So we have evidence as presentation and evidence as established fact. What's the third way evidence gets used?
The third way is where it gets even more conceptual. Here, evidence is thought of as this inferential link. It's a fact that allows you to infer another fact, something that's important to the case.
Oh, I see. So it's like a bridge, a connection between one piece of information and another.
Precisely. The Stanford entry uses the term factum probans for the fact that's presented as evidence, the inferential premise, if you will, and factum probandum for the fact that you're trying to prove the conclusion you're trying to reach.
I remember those Latin terms from my logic class. Okay, so let's try to ground this with an example. Let's say, in our theft case, investigators find the accused's fingerprints on the jewelry display case.
Perfect. So the fingerprints themselves, that's the factum probans. It's a fact established through real evidence that the accused's fingerprints are there. But what we're really interested in is whether the accused was actually at the scene, right?
Right, because that would link them more directly to the crime.
Exactly. So the presence of the fingerprints is evidence in this third sense because it allows us to infer the factum probandum, which is that the accused was physically present at the jewelry store.
Okay, so it's not just that the fingerprints exist. It's what we can infer from that fact, the presence of the accused, that makes it evidence in this sense.
Precisely. And this is where relevance comes into play, right? The fingerprint evidence is relevant because it helps to establish a fact that's material to the case. In contrast, let's say we find out the accused's favorite color is blue.
Well, unless there's some, really bizarre connection we're missing, that fact doesn't seem to tell us anything about whether they committed the theft.
Exactly. And the Stanford entry points out that Bentham, back in 1825, kind of ridiculed the idea of irrelevant evidence. He said, if something's irrelevant, it's basically useless, it has no bearing on the case, so it's not really evidence at all.
So it's a bit of a contradiction in terms irrelevant evidence.
Right. In this third conception of evidence, it just doesn't make sense because evidence is all about that inferential connection, that link between a known fact and a fact we're trying to prove.
Okay, so just to recap, evidence is presentation, evidence as established fact, and evidence as a relevant premise for an inference. Three very distinct ways of using the term.
Right. And the Stanford entry emphasizes that usually you can figure out which meaning is intended from the context of the discussion. Yeah. But it's definitely something to be aware of, especially when you're trying to analyze legal arguments and reasoning.
Absolutely. So now that we have a better grasp of how evidence can mean different things, let's move on to that second key area. You mentioned those conditions for something to even be considered evidence in court.
All right, so now we're talking about, what are the hurdles? What are the tests that something has to pass to even get in the door, to even be considered by the fact finder? The Stanford entry identifies three main conditions: relevance, materiality, and admissibility.
Okay, and I think we've already been dancing around relevance a bit.
Yeah.
It seems like the most, intuitive requirement. If something's not relevant, it shouldn't matter, right?
You'd think so. But as with everything in law, it's a bit more nuanced than that. Relevance is absolutely crucial, as a legal scholar named Thayer pointed out back in 1898. He said the whole idea rests on two fundamental principles. One, nothing that's irrelevant can be received as evidence. And two, with certain exceptions, everything that is relevant is receivable.
So irrelevance is a hard no, but relevance is generally a yes, but with, some caveats.
Right. And actually, this idea is even codified in modern legal rules. In the U.S., for example, you have Federal Rule of Evidence 402, which basically says the same thing. Irrelevant evidence is inadmissible. Relevant evidence is admissible.
Okay, so it's not just some abstract principle. It's actually written into the rules of evidence. But what does relevant mean in this, legal sense? We keep using the term, but we need to pin it down.
You're right. And this is where we get into some interesting territory, because there's actually some debate about whether relevance is purely a logical concept, as Thayer argued, or whether it has a legal dimension as well.
Oh, interesting. So, is it just about logic and reasoning, or does the law itself shape what counts as relevant?
Exactly. But let's focus on the logical conception for now. The most common way of understanding relevance, logically speaking, is in terms of probability.
Okay, probability. So we're talking about likelihood, chances, that sort of thing.
Right. Both Stephen, who we mentioned earlier, and the Federal Rules of Evidence, they both use the term probable in their definitions of relevance. The idea is that for something to be relevant, it has to make the existence of a fact more or less probable than it would be without that evidence.
So it can't be neutral. It has to actually shift likelihood in some direction.
Exactly. And sometimes this idea of probability gets a mathematical interpretation. The Stanford entry uses a great example from a legal scholar named Lempert involving blood types. Imagine a crime scene where the perpetrator's blood type is found to be type A, and let's say the accused also has type A blood.
Okay, so that seems relevant, but how do you actually measure that relevance?
Well, one way is to use what's called a likelihood ratio. You basically compare the probability of finding type A blood at the scene if the accused is guilty versus the probability of finding it if they're innocent. The likelihood ratio is essentially a way to quantify how much more or less likely the evidence is under each hypothesis.
So if type A blood is super common, like half the population has it, the likelihood ratio wouldn't be very high, right? Because it's almost as likely to find that blood type whether the accused is guilty or not.
Exactly. But if type A blood is rare, let's say only 25% of the population has it, then the likelihood ratio goes up, because now it's more likely to find that blood type at the scene if the accused is guilty.
Okay, so the rarer the blood type, the more relevant the match becomes, because it makes it more probable that the accused was there.
Precisely. The greater the difference in those probabilities, the higher the likelihood ratio, and generally speaking, the more probative value that piece of evidence is considered to have.
Okay, that's pretty clear. But the Stanford entry also mentions that not everyone agrees with this strictly mathematical interpretation of probable.
That's right. Some argue that probable in the legal definitions of relevance might not have been intended as a precise mathematical probability. They say it could just mean, that the evidence offers some reason to believe the fact is true or false without needing to quantify it.
Okay, so a more general sense of making something more plausible or less plausible.
Exactly. And there are other criticisms of the purely mathematical approach. One example is that sometimes evidence that seems intuitively relevant wouldn't meet the mathematical threshold.
Can you give an example?
Yeah, the Stanford entry mentions this example from a legal scholar named Allen, where the accused is known to have driven to town on the day of the crime. Now, that fact might be consistent with both the prosecution's theory. Let's say they argue the accused drove to town to commit the murder, and the defense's theory. Let's say they claim the accused was visiting their mother.
So, from a purely mathematical perspective, that fact of driving to town wouldn't change the likelihood of guilt or innocence.
Right, because it fits both narratives equally well. But in a real court case, that evidence would almost certainly be admissible because it provides context. It helps to build a story, even if it doesn't mathematically increase the probability of guilt.
That makes sense. It's not just about a single fact in isolation. It's about how that fact fits into a larger narrative, how it contributes to our overall understanding of the situation.
Exactly. And this example has led to other conceptions of relevance. One is called the explanatory view, where evidence is considered relevant if it helps to explain or support a party's version of events.
So even if driving to town doesn't mathematically prove the accused committed the murder, it still supports the prosecution's story of how they got there. It fills in a gap in the narrative.
Precisely. Relevance in this view is not just about bumping up the probability of a hypothesis. It's about how the evidence helps us to make sense of the situation, how it fits into a coherent explanation.
Okay, so that's logical relevance with some interesting debates about how to understand probable. But now, what about that other issue you mentioned, about whether relevance is purely logical or whether it has a legal dimension?
Right, this is where Wigmore enters the picture. He argued that contrary to Thayer, relevance actually does have a legal component.
Okay, so what were his arguments for this legal dimension of relevance?
Well, he had a couple. Firstly, he said that in law, you need a higher degree of probative value for something to be considered relevant. He called it a plus value. And he thought this was necessary to, protect juries from being swayed by weak or misleading evidence.
So it's like the stakes are higher in a legal context, so the relevance bar has to be higher as well.
That was his idea. He thought that in everyday life, we might accept weaker evidence for our beliefs. But in court, with freedom and justice at stake, you need something more substantial. He was worried about juries being misled by emotional appeals or, prejudiced by certain types of evidence.
Okay, that's an interesting point. But I mean, isn't that what the rules of admissibility are for? Like, we have rules that exclude certain types of evidence, even if they're relevant, like hearsay, for example.
You're right. And the Stanford entry actually points out that some critics of Wigmore say this idea of a plus value for legal relevance is kind of conflating things. They argue that admissibility rules are specifically designed to address those concerns about prejudice or confusion.
So, like, relevance is about the logical connection, the inferential link, and admissibility is about whether the evidence should be allowed, despite its relevance, for policy reasons, or to protect the fairness of the trial.
Exactly. And they point to Federal Rule of Evidence 403, which actually allows a judge to exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice or misleading the jury.
Okay, so it seems like Wigmore's plus value argument might be blurring the lines between those two distinct concepts, relevance and admissibility.
That's one way to look at it. But Wigmore had another argument for the legal nature of relevance. He said that judges are actually bound by precedents when they make rulings about whether evidence is relevant. He even cited a specific case, State v. LePage, where the court argued that over time, repeated rulings by judges about the relevance of certain types of evidence that can essentially create legal precedent.
So it's like the collective wisdom of judges over many cases can actually solidify what counts as relevant in specific situations.
Right. Wigmore argued that this process, this accumulation of judicial decisions, actually gives relevance a legal dimension. It's not just about abstract logic anymore. It's about what the courts have decided in the past.
Okay, I see. But, I mean, isn't relevance always context dependent? Like, what's relevant in one case might not be relevant in another, even if it's the same type of crime.
You're hitting on a key point there. The Stanford entry actually points out this potential problem with Wigmore's view. It's hard to see how a precedent about relevance in one specific case can be truly binding in another case with different facts and circumstances.
Right, because the details matter, the context matters, and even if two cases seem superficially similar, there are always going to be subtle differences that could affect what's relevant.
Exactly. So while legal systems do provide these, general definitions of relevance, the application in practice often seems to rely heavily on that extra-legal realm of logic and experience that Thayer emphasized. Judges have to use their judgment, taking into account all the specific details of the case.
Okay, so it's a complex interplay between these formal legal rules, like the definition of relevance, and the judge's understanding of logic and common sense, and their interpretation of precedent.
Precisely, and I think that's part of what makes the concept of relevance so fascinating from a philosophical perspective. It's not just a cut-and-dried matter of applying a rule. It involves judgment, interpretation, weighing different factors.
Absolutely. Okay, so we've explored relevance in some depth.
Mm-hmm.
What about that second condition for receiving evidence materiality? What does that add to the mix?
Right, so materiality is about making sure that the evidence is actually legally significant to the case. It's not enough for something to be logically relevant. It also has to matter in terms of the legal issues at stake.
Okay, so it's like a second layer of filtering.
Exactly. Materiality is determined by the applicable law, like the specific criminal statute or the elements of a civil claim. It's about ensuring that the evidence is directed at something that the law actually cares about.
So, like in our theft case, evidence about the value of the stolen jewelry would be material, because the law cares about that it determines the severity of the charge. But evidence about the accused's taste in music wouldn't be material, unless there's some weird legal rule about that.
Exactly. Materiality is about aligning the evidence with the legal framework of the case. The Stanford entry gives this really stark example involving a rape case. Imagine there's evidence suggesting the alleged victim consented to sexual intercourse. Now, that might be logically relevant to the issue of consent.
Right, because it seems to contradict the idea that it was non-consensual.
Exactly. But if the alleged victim is a minor, her consent is legally irrelevant. The law says that a minor cannot legally consent to sexual intercourse with an adult.
So even though the evidence is logically relevant to the question of consent, that question itself is immaterial to the legal charge.
Precisely. Because the law doesn't recognize consent in that context. So even if the evidence is true, even if it establishes the fact of consent, it doesn't matter legally. It's not material to the case.
Okay, that's a powerful example. It really shows how materiality is a legal filter. It determines what facts the law actually deems significant in a particular type of case.
Right. And the entry points out that this is where confusion can arise, because sometimes people use the term relevance broadly to include both logical relevance and materiality. But it's helpful to keep them separate conceptually.
Agreed. Clarity of terms is always a good thing, especially when we're dealing with complex concepts like evidence. Now, the entry also mentions this term, facts and issue. How does that relate to materiality?
Right. A fact and issue is basically a material fact that's actually being disputed by the parties in the case. So not all material facts are necessarily facts and issue.
Okay, I think I'm getting it. So let's say in our theft case, both sides agree that the jewelry was stolen, and they agree on the value of the jewelry, but they disagree on whether the accused was the one who actually stole it.
Exactly. In that scenario, the fact of the theft itself and the value of the jewelry, those are material facts, but they're not facts and issue. The only real fact and issue is the identity of the thief.
So you can't just bring in any evidence about any material fact. It has to be a fact that's actually in dispute, something the parties are arguing about.
Right. And the Stanford entry notes that there are some variations in how this is applied. California, for example, has a specific requirement for the fact to be disputed, while the federal rules are a bit more lenient on that point.
Okay, interesting. So there's some wiggle room, as always. But the core idea is that the evidence has to be directed at a legally significant matter that's actually being contested in the case.
Exactly. It can't be a side issue. It has to be a central point of disagreement.
Got it. So we've navigated relevance and materiality, those two initial hurdles for evidence. But even if evidence is relevant and material, it can still be excluded under the third condition, admissibility. This is where those specific legal rules of evidence come into play, right?
Absolutely. Admissibility rules are like those very particular legal filters that can prevent evidence from being presented at trial, even if it meets those basic criteria of relevance and materiality.
So like the hearsay rule, which we mentioned earlier, you can't just testify about something someone else told you, even if that information seems relevant to the case.
Precisely. Hearsay is a classic example of an exclusionary rule. And there are many others like rules about character evidence, rules about privileged communications, all sorts of specific situations where the law says, no, this type of evidence is not allowed.
And the Stanford entry is careful to point out that it's not really accurate to call irrelevant or immaterial evidence inadmissible.
Right. Inadmissibility should be reserved for situations where evidence is excluded for these other specific legal reasons, not just because it fails those basic tests of relevance and materiality.
Okay, that's a helpful distinction. So it's like there are different levels of exclusion. Something can be excluded because it's just plain irrelevant, or it can be excluded because it's relevant but not legally important, or it can be excluded because there's a specific rule that prohibits that type of evidence.
Precisely. It's a hierarchy of exclusionary principles. And this distinction was actually emphasized by Montrose, who we mentioned earlier. He argued that admissibility rules serve different purposes than those basic requirements of relevance and materiality. They're often about broader policy considerations like fairness, efficiency, or protecting certain rights.
Okay, so different reasons for exclusion, different levels of filtering. Now, this brings us back to Stephen and his somewhat controversial view on hearsay. Remember how he said hearsay is not relevant?
Yes, and that caused quite a stir among legal scholars. Many pointed out that hearsay statements can definitely have probative value. Like, if someone told you they saw the accused fleeing the scene, that statement might make it more likely that the accused was actually there, even if it's secondhand information.
Right, so it seems like Stephen was conflating admissibility with relevance. He's basically saying that because hearsay is inadmissible, it's therefore irrelevant, which isn't logically sound.
You're right. And critics like Whitworth and Thayer, they were pretty clear about that. They said hearsay is generally excluded despite its potential relevance, not because it's inherently irrelevant.
But Stephen did have some justifications for excluding hearsay, right? He was concerned about judges relying too much on secondhand accounts. and he worried about the potential for fraud or fabrication when the original speaker isn't there to be cross-examined.
Exactly. Those were his main concerns. And the Stanford entry actually offers an interesting defense of Stevens, suggesting that maybe we should think of many exclusionary rules as being about regulating certain types of reasoning, not just about blocking specific facts.
Okay, I'm intrigued. How does that work?
Well, take hearsay again. The rule is often phrased as prohibiting the use of an out-of-court statement to prove the truth of what was said in that statement. So it's not just about blocking the content of the statement, it's about preventing a specific type of inference, a specific way of using the statement to reach a conclusion.
Okay, so like you can't use someone else's statement as proof that what they said is true, but you might be able to use it for a different purpose.
Exactly. And Roberts and Zuckerman, they famously said, there's no such thing as hearsay evidence, only hearsay uses, which highlights this idea that it's not the statement itself that's problematic, it's the specific inferential move you're making with it.
That's a clever way of putting it. So it's about regulating the reasoning process, not just censoring information.
Right. And the entry gives other examples of rules that seem to work this way, like Federal Rule of Evidence 404, which generally prohibits using evidence of someone's character to prove they acted in accordance with that character on a specific occasion.
Oh, right. Like you can't say, this person is a liar, so they must be lying now.
Exactly. And character evidence probably does have some probabilistic relevance, right? Like if someone has a history of violence, it might make it slightly more likely they committed a violent act.
But the law says, no, we're not going to allow that kind of reasoning. It's too prejudicial. It's too likely to lead to unfair verdicts.
Precisely. So it's a normative judgment, a judgment about what kinds of reasoning are acceptable in a legal context, even if those reasoning patterns might have some statistical validity.
Okay, so this leads to the idea of a normative conception of relevance, where inadmissible evidence can be thought of as irrelevant in the sense that it shouldn't be used in that particular way, due to these policy concerns about fairness or the integrity of the legal process.
Right. It's like saying, even if this evidence has some logical force, we're not going to allow it to be used in this way because it would undermine the values we're trying to uphold in our legal system.
Okay, I'm following. So these admissibility rules, they're not just arbitrary obstacles. They're serving a purpose. They're embodying certain values and priorities within the legal system.
Exactly. And the Stanford entry discusses some of the historical reasons behind these rules. One common theory is that they were developed in connection with the rise of the jury system.
So the idea was to protect juries, who weren't necessarily legal experts, from being misled by certain types of evidence.
Right. There was this concern that lay jurors might be too easily swayed by emotional appeals, or that they might give undue weight to certain types of evidence, like hearsay or character evidence.
So this is a form of epistemic paternalism. The law is trying to guide jurors towards more reliable forms of reasoning, even if it means excluding some potentially relevant information.
Precisely. Though, as the entry notes, there's some debate about the historical accuracy of this account, and it doesn't fully explain all admissibility rules. Plus, even in the systems where judges are the primary fact finders, there's still an argument to be made that some constraints on the evidence they consider might be beneficial.
Right. It's not just about protecting juries. It's about ensuring a fair and reliable process, regardless of who's making the ultimate judgment.
Exactly. Now, one really interesting perspective on admissibility comes from Bentham, who, as you might know, was a strong advocate for legal reform. He was extremely critical of most exclusionary rules.
Really? He didn't think they were necessary.
No, he was all about what he called freedom of proof. He believed that the primary goal of the legal system should be to reach the most accurate decision possible, and that excluding relevant evidence hindered that goal.
So he thought pretty much everything should be admissible unless it was clearly superfluous or caused undue delay.
That was his basic position. He argued that any evidence that might help to establish the truth should be allowed, and that judges should have wide discretion in deciding what to admit.
Okay, that's a pretty radical view, and I can see how it would appeal to a philosopher, right?
Yeah.
The pursuit of truth above all else.
Right. But the Stanford entry points out that Bentham's view has been criticized for being a bit too simplistic, for maybe undervaluing things like procedural fairness and individual rights.
Right, because just because something's relevant to finding the truth doesn't mean it should be allowed into court. We have rules against coerced confessions, for example, even if those confessions might be true.
Exactly. And there are concerns that, if judges had too much freedom to admit evidence, they might be more susceptible to bias or pressure from powerful parties.
So it's a delicate balance between seeking the truth and ensuring a fair process.
Exactly. And there are other justifications for admissibility rules besides those we've already discussed.
Hmm.
One is that they can actually incentivize parties to produce more reliable forms of evidence.
Oh, interesting. So like if you know that hearsay is generally inadmissible, you're more likely to try to track down the original speaker and get them to testify directly.
Right. It encourages better investigative practices. And there's also the idea that admissibility rules can help to allocate the risk of errors in fact finding.
Okay, what does that mean?
Well, any legal system is going to make mistakes, right? Sometimes innocent people get convicted, sometimes guilty people go free. Admissibility rules can be seen as a way to, like, distribute those risks in a way that's considered fair or just.
So like maybe the hearsay rule is partly about saying we'd rather risk letting a guilty person go free than convicting an innocent person based on unreliable evidence.
Exactly. It's a way of erring on the side of caution, so to speak. And there are even arguments that admissibility rules can help to promote public confidence in the legal system. The idea being that if people see the courts following clear rules and excluding certain types of evidence, they're more likely to trust the verdicts that are reached.
That makes sense. It's about maintaining legitimacy and the appearance of impartiality.
Precisely. So you see, there's this whole web of reasons behind admissibility rules. It's not just about logic or even about finding the truth. It's about balancing various competing values and goals within the legal system. Host speaker.